when we're talking about cutting into
Senate Armed Services Subcommittee on Personnel meets this afternoon to receive testimony on domestic violence and child abuse in the military. On panel one, we will hear from witnesses about their personal experiences of domestic violence and child abuse, and from a victim advocate. Ms. Adrienne Perry, the mother of military child abuse survivors, Ms. Mercy McKinley, a medically retired Army veteran who sustained injuries as a result of intimate partner violence, and Ms. Iris Vega, senior court advocate, Doorways for Women and Families. I'll introduce the second panel when we transition to their testimony. In the United States, domestic violence, including intimate partner violence and child abuse, are significant problems that cause immense harm in our society. The most current data published by the Centers for Disease Control and Prevention, the CDC, show that 27% of women and 11% of men have experienced either sexual violence, physical violence, or stalking by an intimate partner. And the CDC estimates that domestic violence victims lose nearly 8 million days of paid work and 5.6 million hours of household productivity annually. Additionally, the CDC reports that in 2012, state and local child protective services received an estimated 3.4 million referrals of children being abused or neglected. And an estimated 1,340 children died from maltreatment during that year. Clearly, as a nation, we must do more to address the many factors, relationship, community, and societal, that may lead to domestic violence and child abuse. We must also develop evidence-based prevention strategies and implement comprehensive support programs to help the victims. Let me state, however, that domestic violence and child abuse are not just problems in local communities around the country. They're also a problem within the military services. While the data show that the military's domestic violence and child abuse incident rates are lower than comparable rates in civilian communities, I am deeply disturbed that both intimate partners and children die every year at the hands of military service members. DOD and the services must not rest until they totally eliminate violence and abuse of intimate partners and children within their ranks. I will assure everyone here today that this subcommittee will provide whatever additional resources DOD and the services need to strengthen its programs of prevention and victim support. Finally, I want to thank Ms. Perry and Ms. McKinley specifically for their testimonies today. I know it's not easy to discuss the painful events of the past, events where either you or a family member has suffered as victims of domestic violence and child abuse. I thank you for your courage to speak to us today, to provide us with some important insight into your experiences. Senator Gillibrand.
Thank you, Mr. Chairman. I'm really grateful to you for holding this hearing, and I want to join you in welcoming our witnesses who are here to speak with us about two very difficult topics: intimate partner violence and child abuse in the military. To Adrienne and Mercy, thank you for being here to share with us what I can only imagine were very painful experiences for you. Your bravery is inspiring. In 2005, 5-year-old Talia Williams was killed by her father and stepmother. Her father was a soldier stationed in Hawaii. This crime happened after months of abuse and after multiple reports to military authorities that were never shared with the civilian child protective services. And in the 12 years since Talia's death, it's clear that this problem has not gone away. Just last year, in the Department of Defense's fiscal year 2016 report on child abuse and domestic violence, they documented 13,916 reports of suspected incidents of child abuse and neglect and 18 child abuse-related fatalities. All of the deceased victims were under 5 years old. Half of them were under 1 year old. The Defense Department's report also documented 15,144 reported incidents of domestic abuse and 9 intimate partner fatalities in fiscal year 2016 alone. And these are just the reported incidents. We still do not have an accurate estimate of the prevalence of child abuse and intimate partner violence in the military because there's no prevalence survey like the one we have for service members on sexual assault and harassment. We only have the reported numbers, and that's not enough. Just as the Sexual Assault Prevalence Survey helps shine a light on the issue, we need to understand the scope of the problem so that we can better do our job supporting service members and their families. Congress has already made some efforts to solve this problem, but it really hasn't been enough. Thanks to advocacy of the Hawaiian delegation, Talia's law was signed into law by President Obama in 2016. It required all personnel who are in supervisory positions within the chain of command to report suspected child abuse and neglect. This law was a good step, good first step, but we need to do much more to prevent these crimes from happening in the first place. We need to help stop the abuse before it begins and properly address it once it happens. To address intimate partner violence and child abuse, we must start by addressing the unique stressors on our military families. The challenges of deployment and reintegration, isolation from support networks, and fears that reporting your service members for violence may result in the end of his or her career and potentially the loss of income and benefits for the family put significant strains on those families. These difficult factors make hard decisions about coming forward even harder. When it comes to intimate partner violence, we must not only look at the psychological consequences of abuse, but also the long-term physical health risks it causes. Approximately 20 million women experience intimate partner violence-related traumatic brain injury in this country every year. One study found that 92% of women in domestic violence shelters in New York State were hit in the head by their partner between 1 and 20 times, and 50% of intimate partner violence survivors are strangled at some point in the course of the relationship. Yet survivors of intimate partner violence are not routinely screened for strangulation or brain injury in emergency rooms, and they often do not themselves realize that they've lost consciousness. In addition to the health concerns posed by these injuries, lack of awareness of their cognitive and behavioral effects, such as loss of memory, confusion, or agitation, can impact the way a survivor is treated during an investigation. First responders and law enforcement personnel who are unaware of these consequences may misinterpret these behaviors as lack of cooperation or a difficult personality and decline to move forward with additional inquiry or intervention. The Family Advocacy Program has grown and improved in the last several years, and I know how hardworking, dedicated personnel who care deeply about the prevention of violence. The implementation of a more structured criteria for evaluating cases and increased, more sophisticated training and education of response personnel is encouraging. However, I believe more can be done and must be done for our military and their families, especially the children who are most vulnerable. For too long, intimate partner violence and child abuse have been characterized as family issues to be kept private. As a result, the violence and trauma of abuse has lived in the shadows. It's time we shine a light on these experiences. I've also received written letters from 3 separate individuals, Captain Levi Fuller, Ms. Jennifer Elmore, and Ms. Selena Meadows, who would like to share their experiences, and I would like to have these statements included in the record.
Without objection.
I hope that today's hearing is the beginning of a productive dialogue that can do just that, shine a light on these issues. I hope we all listen to the survivors of these crimes, listen to the advocates who work on these cases day in and day out, and listen to the experts to truly gain a better understanding of these cases and what we can do to improve our prevention and response. I hope that someday we're all here again talking about how far we've come and celebrating that there are no more cases like Talia's.
Do any other senators wish to make a comment before the testimony?
If I could briefly, I have to
Senator
catch a
McCaskill.
plane, and I want to apologize to everyone who will testify today because I won't be able to stay for all of it. But I think this is such an important topic for us to tackle because if you really understand domestic violence, you realize that the unique characteristics of military service and their impact on the family could in fact be a dangerous petri dish for domestic violence flourishing. And by that I say that one of the biggest challenges we have with domestic violence, I'll never forget when I began the domestic violence unit in Kansas City when I was the elected prosecutor in the 90s, and I had a fight on my hands with the police department and even with my assistant prosecutors. And they said, you know, Claire, we can't prosecute this crime because there's not a witness because the victims always decide they are not going to go forward. And I said, well, we better shut down the homicide unit then. Because we manage to prosecute homicides when the victim doesn't speak. So we need to build a case, and if we build a case, then victims will begin to trust us that we can move forward and find justice and protection for them. But if we just keep doing this circular reasoning, and why I mention the military as particularly a challenge, there is isolation for families within the military, particularly as people are transferred with some regularity. It's not as if many military families have the opportunity to set down roots and have the kind of support system that is so necessary to protect the victims of domestic violence. If there is not a support system in the community, then more domestic violence incidents will end up in homicide incidents. So I am anxious to be part of this. I appreciate you all having this hearing. I do think we need to look at what is that support system right now in the military for people who have been victimized by domestic violence and are trying to find a way forward. Because if it's hard to figure out your personal life going forward, when your partner has a civilian job, imagine how difficult it is if your partner is a member of the military and you are dependent in so many other ways. So I do think it's terrific, and I will follow up and read all of your testimony, and I'll look forward to working with my colleagues, Senator Ernst, Senator Tillis, and Senator Gillibrand, as we try to find better solutions and support for addressing this problem within the Department of Defense. Thank you all very much.
Thank you, Senator McCaskill. We'll now begin with the testimony, and Ms. Perry, we'll start with you.
I would like to thank each and every one of you for allowing me this opportunity to appear before you today and share my family's story, as well as offer my perspective on the prevention, detection, investigation, and treatment of childhood abuse and sexual assault within the military. My name is Adrienne Perry, and I am the spouse of an active duty United States Marine. My husband, Breck Perry, is a major in the United States Marine Corps, serving as an executive officer and is currently deployed. This is my husband's 5th deployment we have gone through together as a family. I have always been so proud of my husband's service to our country, and I have always been so proud to hold the title of a United States Marine spouse. This life has brought us so many amazing opportunities. We have lived in Quantico, Virginia, Camp Lejeune, North Carolina, Oahu, Hawaii, and Okinawa, Japan. Our children have been given the gift of world travel, and through that we have been able to make precious and priceless memories as a family. The patriotism that resides in the heart of each member of our family is immeasurable. Unfortunately, my love for the military was forever tainted by the acts of a colonel named Daniel Hunter Wilson. Wilson was one of my husband's previous bosses in Okinawa. From Okinawa, Wilson was sent to Camp Lejeune, North Carolina, to be the 2nd Marine Expeditionary Force G3 Operations Officer. Shortly after Wilson arrived to Lejeune, our family was moved to Lejeune as well. Wilson was one of the very first people to reach out to us and offer us support when we arrived at our new duty station. Within a matter of a couple of weeks of visiting the Wilson's house, my 6-year-old daughter confided in me that Wilson sexually abused her during that time. This disclosure occurred in the Wilsons' home. Upon finding out this horrible, heinous act had been committed upon our child, my husband and I drove to our house, where we immediately called the military police. We had the MPs at our home in a matter of minutes, as well as Naval Criminal Investigative Service, also known as NCIS. This was the start of the investigation. When NCIS came to our home, we disclosed to them what our daughter had told me. The next morning, we received a call from an NCIS agent asking if we could be at the Onslow County Child Advocacy Center for a forensics interview. This is a child advocacy center that is off base and is civilian run. A couple of NCIS agents met us at the center. While the civilian forensics interviewer spoke to my daughters, NCIS was in a separate room monitoring the interview via a live feed. My daughters' interviews were conducted with no input or follow-up from NCIS. The agent himself later stated that he had left the decisions regarding the interview solely up to the forensics interviewer. A couple of days after we reported what happened to our daughter, NCIS called us to set up a forensics exam. There was a huge challenge finding an expert in the town of Jacksonville, North Carolina, who could do a forensics exam on a 6-year-old child. There were no pediatric forensic exam specialists available in our area to do our daughter's exam. The specialist the Child Advocacy Center utilizes was not available. We were sent 2 hours away to Greenville, North Carolina, to the Teddy Bear Clinic for her exam. As parents, our hearts were shattered. Many days I felt as though I could barely breathe. Just when I didn't think things could get any worse, one of our other daughters shared with us that Wilson had done something to her as well. She too was 6. It was her twin sister. We notified investigators as soon as this was brought to our attention. As the investigation began, it started to seem as though every bit of information, the evidence obtained by NCIS, was information and evidence my husband and I were giving to them. NCIS obtained my cell phone as well as my husband's cell phone and did a complete data dump from both of our phones. We gave them our Facebook password so they could scour through any and all information we might possibly have that could assist with the investigation. I assumed NCIS would be doing the exact same thing with Wilson's devices. However, I was very wrong on that. Wilson's cell phone and computer were never seized to this day.
Oh my God.
I continuously asked about the possible seizure of Wilson's personal electronic devices. The responses I would get varied on the issue. A few times I received responses that made me think they were in planning mode to seize his personal devices, and other times they gave me responses that made it seem as though legally they could not seize his personal devices without causing negative ramifications for our case. I understand that I am not a trained investigator. However, my common sense told me and still tells me that Investigation 101 would have led to the seizure of his personal devices given the charges and allegations against Wilson. I come from a line of law enforcement professionals, both police and FBI, and each and every one of them were appalled and shocked that Wilson's personal computer and personal cell phone were never seized. Despite the near exclusive reliance on me and my husband for the facts, no one from NCIS ever sat down with us to create a timeline or verify facts and dates. My husband and I, on several occasions, questioned why no one was speaking to us to pull together the facts. We questioned how they would be capable of formulating a solid case without speaking to us. As a matter of fact, my husband and I began to feel that this case was too big for NCIS alone. The tentacles were deep, and it required a widespread net to be cast as far as investigative work is concerned. We're talking about a full-bird Marine colonel, one rank shy of being a general, with over 35 years of service, who has been stationed, deployed, or temporary active duty in multiple countries and multiple states across the United States of America. We asked on numerous occasions for a meeting with the Special Assistant U.S. Attorney, also referred to as the SAUSA, in order to discuss possibly bringing in the FBI to collaborate on this case with NCIS. The SAUSA would not meet with us whatsoever. In one of the many attempts to give NCIS information, my husband and I shared with NCIS that prior to coming to Camp Lejeune, Wilson had been abruptly removed within a matter of days from a temporary command he was given, where he was in charge of 6-month exercise between the United States Marines and the Australian Defence Force in Darwin, Australia. We suggested NCIS look into why he was removed from his position. It came out during the investigation that Wilson had made a sexually inappropriate comment to the wife of a United States contractor in Australia. He had sent overly friendly text messages to a female Australian Defence Force major. He drank alcohol excessively. He shared risque photos of one of his captain's wives to the Australian Defence Force commander. And he snuck onto a secure government computer belonging to a female Australian Defence Force contractor and sent out an inappropriate email to the Australian Defence Force commander. This misconduct, most of which was sexual in nature, showed prior similar behavior. Based upon my perception, I do not feel Wilson's prior misconduct was adequately investigated. These allegations led to questions of possible prior sexual misconduct while Wilson was stationed in Okinawa. However, NCIS was non-responsive to investigating Okinawa concerns. Overall, it appeared as though there really was no attempt to delve into Wilson's past to discover prior misconduct, despite the fact that he was charged with a child sex crime. Even after uncovering that Wilson had been alleged to have behaved in such a sexually inappropriate way in Australia, to include nearly nude photos of one of his captain's wives on his Facebook Messenger, NCIS still did not seize Wilson's personal devices. I cannot wrap my brain around the failure of NCIS to act swiftly to obtain evidence from Wilson via his personal devices. This failure has me questioning heavily how lower-ranking service members in situations like ours are treated and how their cases are handled. Nearly 5 months into the investigative process, our case was assigned to 3 powerhouse attorneys who did an unbelievable job in seeing to it that justice was somewhat served for our daughter. Our case eventually went to a general court-martial where Wilson was found guilty for sexual assault of a child, conduct unbecoming of an officer and a gentleman for all charges against him in Australia, and unauthorized absence. Wilson was sentenced to 5.5 years in the military brig. During our trial, I was not given the opportunity to give a victim impact statement on behalf of my 6-year-old daughter. I was reminded of the pain I felt due to my voice being restricted at sentencing when I saw the gymnasts who were victims of Larry Nassar giving their victim impact statements. We were not given that opportunity to be heard. Part of being able to heal from something as traumatic as this is to be able to speak to those who have harmed you. Those gymnasts were given such a gift by having their voices heard. It was a gift we did not receive. In our trial, not only were our voices restricted, but the judge directly addressed the jury and read aloud all of Wilson's military accomplishments, stating for the jury to consider his prior military service to our country when they go to sentence him. I will never forget that moment. It was like a slap in my face as a mother. Hearing his awards, accomplishments, deployments, and leadership accolades be read aloud as if they erased what was done to my daughter crushed me. I sat there speechless, absolutely dumbfounded and in shock as to what my ears were hearing. Then I sat and watched his defense attorney get up and hand a huge album over to the jury that was filled with photos of Wilson as a child all the way up through his adulthood and military career. Where was my daughter's photo album for them to look through as they considered his fate? My personal experience through the investigation process has led me to the following conclusions. Number 1, reports and concerns brought to the people in positions of legal power are not always welcomed or taken as seriously as they should be. In our case, we requested meetings on multiple occasions in order to address concerns we had for our own personal safety. We were often met with absolute refusal to be heard, or when granted a meeting, we had to fight tooth and nail to be heard. For example, we had to fight to have a protective order enforced properly against Wilson. He was being allowed to drive by our home multiple times a day to get to and from work. I should not have to fight to keep my children, my husband, and myself safe. What would the outcome have been for a young Lance Corporal in the same situation? Wilson was not detained for what he did to our daughter until 5 months after we reported what happened. For 5 months, we had to live with Wilson roaming free wherever he pleased on base, living about a half a mile from our house. That was traumatizing, to say the least. We had to restructure our way of life in order to live on base with Wilson due to a state of constant fear for our safety. The only reason he was finally detained was because an adult female came forward alleging that Wilson had sexually assaulted her as well. Number 2, rank matters. I am very concerned how other survivors are being treated who may not have the same resources or the ability to advocate for their case like my husband and I did. And to be quite honest, they should not have to fight to be heard, believed, and taken seriously. I want to make something very clear here. Rank matters in how these cases are treated, and that is unfortunate. I believe wholeheartedly, had my husband and I stayed silent and let the system as it is right now do its job, justice would never have been somewhat served for our daughter. Number 3, there is a serious failure to provide adequate resources for survivors of sexual assault. There's the failure to provide mental health care. The only resource we were given in regards to mental health care was from that of Onslow County Child Advocacy Center. I was handed a sheet of paper with 3 names on it of counselors who specialized in child trauma therapy. 2 of those were on base and 1 was off base. I did not feel comfortable with going on base for any help after what we had suffered at the hands of someone in the military. That left us with one option for emotional help. One, it is not okay that a victim of child sexual abuse is not being afforded more options for mental health than a mere sheet of paper with 3 names on it. Keep in mind that that little help that was offered was not from the military. It was from Onslow County. Our civilians victims legal counsel, who worked pro bono on our case, stepped in and worked tirelessly to find us a therapist that could see our entire family. Let that resonate. Our civilian legal counsel that we ourselves sought out had to fill in the gap for the military and get us the help we truly needed. Where was the military when we needed them? What do the survivors who do not have the resources we had do? What is happening to them? The military needs to adequately provide mental health care resources for survivors of all types of abuse. It is my humble opinion, after our experience and after speaking with many survivors, that the military is failing incredibly short in this arena. Providing mental health care should be on the forefront of must-dos for the military in order for survivors to be able to begin to heal and have the support and help they need and deserve in order to get through this type of trauma and the trauma that comes with having to prepare for and go to trial. There's also the failure to provide sexual assault forensics experts and specialists. After reporting what happened to our daughter, a couple days later, NCIS requested we take our daughter to have a forensics exam. We had to drive over 2 hours away to have our daughter be seen by a pediatric forensics exam specialist because there were not any available to see her in or around Camp Lejeune, North Carolina. My daughter and every other survivor of sexual assault should be afforded a prompt, readily available forensics exam. It is unacceptable to me that we had to drive for 2 daunting hours to take our child to do something no parent should ever have to take their child to do because the resources required were nowhere to be found within our vicinity. Number 4, there is a lack of properly trained investigators. In our case, NCIS failed to seize Wilson's personal cell phone and his personal computer. I question why there was such refusal to seize his devices. They also failed to thoroughly delve into Wilson's past in order to connect and look into prior similar behavior. Another concern is that NCIS did not seem to be properly trained in regards to how child forensic interviews should be carried out and handled. This is evident by the lack of a follow-up interview with my children. NCIS was not quick to respond to obtaining any evidence whatsoever from the accused. The sole means of evidence collection should not be from the victim. Their failure to promptly obtain evidence resulted in very little evidence being collected from Wilson. Although there were 2 personal hard drives found belonging to Wilson right before the trial began, they were not discovered in enough time prior to trial to be used in any way for trial or charge purposes. NCIS had plenty of time to put forth a solid investigation, but it came across as though our case was not a priority. Wilson went to trial with over 20 charges against him. It is my belief that had NCIS conducted a more thorough and solid investigation, more of these charges would have stuck. A finding of not guilty is not a finding of innocence. NCIS was apparently not trained in such a way that provided a proactive role in our case. The investigators working sexual assault cases need to be trained more thoroughly. Their lack of knowledge in how to properly handle and investigate these sensitive cases is failing survivors and making the possibility of justice nearly impossible. We deserve so much better. Number 5. There is inadequate sexual assault prevention follow-through from commanders. Yes, there is plenty of training being given to these commanders, but where is the follow-through? This was evident in the lack of response to the concerns and red flags that were raised in regards to Wilson's prior misconduct in Australia that was sexual in nature. Had Wilson's command properly addressed the many reports of misconduct from Australia, Wilson would never have been able to take our child's innocence from her. Commanders need to know how to identify red flags, take them seriously, and respond accordingly. It took an Australian commander to point out to the American Marine commanders that the Marine Corps had a serious problem on their hands with Wilson. How did our own military miss this? Catching and acting on those red flags is the vital step that is missing in our military when it comes to prevention. These predators are not being caught until it's too late and another human being's life is torn apart. The cost of failing to prevent these predators is too high to just turn a blind eye. In our case, the cost was that of my 6-year-old daughter's innocence. I will never be able to fix that or get her innocence back for her. The evil that was done to her is an evil only God can redeem. But it's an evil that the Marine Corps could have prevented. I cannot stress enough the need for military leadership to identify red flag behavior. And not only do they need to identify this behavior, but act on it promptly. Finally, trained legal professionals should be spearheading these cases. Our team of attorneys, Lieutenant Colonel John Stevens, Captain Sam Adams, and Captain Corey Wheelert were nothing short of a powerhouse team. Each one of them brought something powerful and important to the table. If it were not for these men coming on board nearly 5 months after we reported what happened to our daughter, we would never have had any hope of seeing justice somewhat served. They were phenomenal. When they stepped in, it was as if order had finally come. The importance of the legal professionals cannot be overlooked and needs to be embraced and supported. There also needs to be a focus on ensuring that survivors of all types of abuse are afforded victims' legal counsel. I don't know what we would have done without our military VLC, Major Nathan Cox, and our civilian team of VLCs from Arnold and Porter. They were our voice, and without them, we would never have been heard. In closing, I would like to thank you all again for your time. I want everyone to understand that I love our military, and I love the United States Marine Corps. Yes, what happened to our daughter shook our world up, and it changed so much in our lives. What Wilson did to our daughters changed them permanently. This devastation done to our daughters crippled my husband and I to our core. I personally grew very angry. But what I realized is that my anger was and is righteous. Part of that anger and hurt stems from the fact that the very institution that my husband and I have remained loyal to for over 18 years and continue to remain loyal to despite what we have suffered, has still yet to offer a simple apology for what was done to our daughters. I knew I had to take the hurt and the pain and the anger and the evil done to our family and do good. I am here today to do good for our military and our Marine Corps. I am here in hopes that my voice will be heard on behalf of all survivors of abuse, so that the principles and values of what the Marine Corps and our entire United States military were founded on can be salvaged. It's extremely unsettling to me that the first question I am asked when people find out that I'm advocating on this matter is, how has this affected your husband's career? It is a serious problem when advocating for what is right and good in regards to child sexual abuse is looked at as a threat to positive progression in the career of a service member. If our military continues to turn a blind eye to the dark culture breeding in our military's ranks, the military will be the victim of their own demise. This culture has to be attacked. The enemy is not always fought abroad. In this case, it's staring us right in the face in our very own ranks. Our country is the great force that it is because we have fought for and accepted change over time throughout the history of our nation. This very same concept applies for our military and how cases of abuse are handled. We can no longer accept the current handling of these cases. Times are changing, and the military should be the first to not only adapt, but act, setting the tone for all institutions on how these cases should be handled. We are known for our powerful armed forces, and the fact that this is happening in our own ranks is a sign of weakness to the rest of the world. It is a mission the military, the United States military, is failing at currently. The military should be the institution that is setting the precedent in what right looks like in regards to how these cases are investigated and treated. It's time for military leadership to become part of the solution. As a mother, I will not stop fighting for justice for my daughters and for those who cannot fight for themselves. Thank you so much for your time.
Thank you, Ms. Perry. Ms. McKinley.
Senators, thank you for having me today. My name is Staff Sergeant Retired Mercy L. McKinley from the United States Army, and I'm a survivor of intimate partner violence in the military. I'm here today to be on the front line to share my experiences and recommendations in an effort to improve the military's approach towards domestic violence as a whole. I am going to disclose the following: the type of abuse I experienced, my interaction with the Killeen Police Department, the type of medical care I received, my process with the Family Advocacy Program, experiences with other survivors prior to separation from service and after separation from service, the process I took to even receive the justice rendered that I now questioned, and the overall recommendations based upon the aforementioned. While stationed at Fort Hood, Texas from September 2014 to January 2015, I was involved in an intimate relationship with a military member of an equal rank. During the course of this relationship, I was both strangled and beaten. I was strangled in such a manner that I had to take muscle relaxers long after just to be able to talk, eat, and swallow. The measures I was using to conceal the extent of my injuries was not working. After 3 days of attempting ice packs, I elected to be seen at the Troop Medical Clinic, in which I was prescribed muscle relaxers. In January 2015, I was physically assaulted that resulted in significant bruising in my torso, legs, back, arms, and additional damage sustained to my prosthetic knee. At the time, I was being medically retired for failure to progress in a certain amount of time following a left total knee replacement and other treatments to address the wear and tear that deployment and military assignments had placed upon my body. During the assault, the service member repeatedly struck, kicked, and stomped in the area where I had my implant, which had caused it to become loosened. In June of that year, I had to undergo surgery to repair the additional damage. Immediately following the assault, I reported it to the Killeen Police Department, in which I was greeted by both the male and female police officer. The male police officer took my statement, while the female police officer's responsibility was to photograph and document my injuries. While I was attempting to explain the cuts on the inside of my lip, the female officer replied, "Oh, it's not that bad." From this statement alone, I deduced that she was not taking myself seriously. At the conclusion, I was given the card of the male police officer on duty, whom advised me that usually the full extent on one's injuries does not surface until the following morning. The next morning, I noticed I was sore, had significant bruising in certain areas of my body, my breathing was labored, and I was limping. Rather than report to early accountability formation in that condition, I went to Carl R. Darnell Hospital emergency room to be seen. I explained what happened to the attending physician who completed my exam and ordered x-rays to ensure I didn't have internal injuries or bleeding. The attending physician asked if I was sexually assaulted as well, in which I denied, and I was prescribed additional pain medications. I was released, but neither medical personnel from both the Troop Medical Clinic nor the Carl R. Darnell Hospital emergency room elected to notify the military police. I confided in a female non-commissioned officer within my unit who recommended that I go to Family Advocacy to seek additional care and counseling. Under her recommendation, I went to Family Advocacy on Fort Hood, Texas, and completed an initial intake. During my intake, the representative asked if I wanted to complete a restricted or unrestricted report, and they completed a matrix. Based upon my response to the matrix, the representative excused herself to go speak with the director. Due to the severity score received from the matrix, I was advised that a restricted report was not an option, as my overall safety was at stake. I was also informed that I was perhaps desensitized and in denial that I couldn't see the escalation of abuse nor how it affected my overall safety. I was provided a packet that included information on how to file a pro se protective order, my responsibility to complete the enrollment in family advocacy program, and a safety plan. The next day, I contacted the district clerk office of Bell County, Texas, to inquire about what all was needed for the pro se protective order. I was told I would need copies of medical evidence and anything else that would support my request for an order of protection. I had to go to the Carl R. Darnell Hospital Correspondence Office to obtain copies of every time I was medically seen for the abuse. This took some time because I had to wait for clearance from my supervisors to grant me permission to take care of what was required. I also had to wait until the hospital correspondence office retrieved the copies of my exams from my medical records. Depending on what is required to be retrieved from your medical records, it can be an immediate response, a 72-hour turnaround, or as long as a month. Once I had what was required, I went to the district clerk office to file my pro se protective order request in person, which I had to wait majority of the day for it to be accepted, approved, signed by a judge, and given a court date. From there, I had to take all of the approved documentation myself, the temporary protective order, and court date to the Killeen Constable Office so they can in return serve the accused. Before the accused could be served, the Killeen Constable Office had to coordinate with the Fort Hood Provost Marshal Office to serve the papers on a military installation, as the accused was trying to avoid being served off post. I cannot definitively say the time frame this process took, but it was neither immediate nor within a one-day time period. I was accepted by the Lone Star Legal Aid to assist with my upcoming court hearing in reference to my protective order. The day of the first court date, the judge delayed the hearing to provide the accused ample time to seek legal counsel, as well as fulfill his financial obligations to the court. In between the period of waiting for the next court date of February 18, 2015, the accused had contacted my legal aid to try to get the protective order amended to suit his needs. My legal aid called me and said directly, "Ma'am, I think he is just trying to save his career and convince me to oblige of his request." I wasn't clear as to her stance and whose side she was on directly, so I fired her. In an effort not to be without legal representation by the next court date, I tried to find an attorney within a local vicinity. It took me going through a total of 10 attorneys to find one whom didn't attempt to throw me out of their office and accept a payment plan based upon their fees. Needless to say, my 2-year protective order was granted on February 18, 2015. The presiding judge, whom was a retired colonel from the JAG Corps, distinctly asked me if I knew the difference between a civil court and a criminal court. She also asked why weren't any charges filed. I responded with the detective assigned was hard to reach, and I was also informed that they were backed up with other cases, and that was the explanation that I received as to why no charges were filed. She was flabbergasted in a sense, but advised my attorney to make sure I obtained a copy of the court transcript and proceedings to provide to the Killeen Police Department and the military. She ordered the accused to reimburse my attorney fees, pay the court, and adhere to the 2-year protective order. The victim advocate from Family Advocacy Program, who accompanied me to court, assisted with obtaining the written military protective order once the civilian protective order was granted. My attorney informed me that I was the first case in which the judge ordered the accused to reimburse the attorney fees and given a direct order to provide the court transcript to the local and military authorities. I met with my attorney once more, whom said directly, and I guess this was just his opportunity to try to properly advise me. He said, "I'm going to advise you as if you were my own daughter, standing before me." He said, "Do you honestly think the Killeen Police Department is concerned about a few cuts and bruises here and there? If you want justice in any form, you need to knock on the doors of Third Corps, which is Fort Hood, Texas, and the General over Fort Hood, Texas. I've seen too many cases like this, and the military needs to do something. Under his advisement and insistence from the judge, I followed and commenced the process. I paid for the court transcript, and I contacted the Third Corps Commander's secretary asking to be placed on his calendar. Furthermore, I met with the supervisor of the detective to express my concerns with the lack of investigating. I spent majority of the time thereafter pleading with both parties to transfer jurisdiction to the military. The military took jurisdiction, Criminal Investigation Division performed their investigation, and the Family Advocacy Program Case Review Committee convened. Both the Family Advocacy Program case and the Criminal Investigation Division came back rather quickly with the result of founded. Charges were conferred for a court-martial. However, the accused was administratively separated in lieu of the court-martial, and I now question the full extent of whatever consequences the accused actually received. Prior to this, the prosecuting attorney kept advising myself that she represented the chain of command and the chain of command's best interests. This was to make it abundantly clear that she was not my attorney. However, due to the rapport I am assuming she and I developed, she had expressed frustration with previous cases in a generalized manner. She expressed her confidence of dotting all of her I's and crossing all of her T's to ensure a conviction and failed to obtain one. She also expressed in confidence of how, after selecting the panel for court, some members still hold firm to the belief of why didn't they just leave, or assaults occur in dark alleys by complete strangers. I was provided a copy of the case review committee results, and an attorney from his chain of command was content with the results because at least something was done. The key takeaway from this whole process is what I had to do and the effort it took on my part. Not all survivors of intimate partner violence are the same. If we go forward expecting this to continue to be the process in any way, shape, or form, justice could be delayed or even denied. The cycle of abuse will continue because some will compare the amount of effort it takes in an attempt to compartmentalize and rationalize the abuse as a means to stay in a situation. Prime example, in 2017, after separating from service, I encountered a female friend whom was active duty and in the Navy. Her civilian husband had punched her in the face while she was holding their infant daughter and attempted to push both of them down a flight of stairs. She approached me with her situation, and I immediately advised her to see the Navy's Family Advocacy. They handed her the same packet I was provided. Where she and I differ was no reference list was given of legal aid services. Finally, she and I contacted the House of Ruth. She rarely had any contact with her legal aid, and when she did, it was minimal at best. A blanket service was being provided rather than curtailed to her situation. When she attempted to change the locks of her own home, she was advised she was not allowed to do that. In addition, her husband had control of all of the finances. She could not afford a real attorney, nor could she adequately afford Pampers and necessities for her child. I told her to contact the Navy's version of the Army Emergency Relief of her command financial non-commissioned officer. She was denied financial assistance. I cannot definitively say what became of her situation because our contact became few and far between by her choice as she dealt with what she was facing. Despite my providing her financial support or trying to develop ways to afford an attorney retainer fee for her, it was not enough. I tried my best to advise her based upon my own personal experiences. Her unit didn't even attempt to grant her accommodations on a military installation, which is local here, since she was advised she was not allowed to change the locks on her home. Throughout my process, I still had to complete the mandatory counseling through Family Advocacy. There was a slight miscommunication with scheduling my appointment to be seen to enroll in the mandatory counseling required. The receptionist was attempting to place me within a support group prior to be seen by a licensed clinical social worker. The normal process, and should be the process, is for the licensed clinical social worker to first determine if one-on-one counseling sessions would be more suitable for treatment as opposed to group sessions. During the group sessions, we were provided handouts that predominantly covered the warning signs of abuse. The start of each group session was to discuss the warning signs of abuse, where we were in the process with regards to our cases. Some sessions included spouses and military personnel expressing trying to reconcile with their abuser cutting off utilities, freezing their bank cards, not being able to get a hold of anyone within their abuser's unit, not receiving adequate assistance, etc. There were some spouses from foreign countries and other spouses whom did not know their abuser's unit, where they specifically worked on a military installation, or where important agencies and resources were located. Quite frankly, some appeared as though they were at their breaking point. The civilian that was running the group sessions sat stoic in a sense, determined to keep us all on track with the handouts provided. I almost equated this experience to being a student under the care of a substitute teacher whom provided us busy work. What had occurred was I connected with some of the spouses that expressed not knowing where certain agencies and assistance was located both on the military installation and locally. I had arranged a time after our group sessions to personally take them from point A to point B. If a spouse indicated that they have not heard from their victim advocate, which was quite often, or direct representation from family advocacy in X amount of days, I would physically take her to the FAP to be seen. On one particular incident, a spouse was told quite frankly in an abrupt manner, "You need to get a job." This was in response to expressing the utilities were shut off purposely by the abuser or withholding financial assets. It was the manner in which the spouse was spoken to that I had a direct problem with. This very same spouse was without a GED, as it was required for her to support her husband's career, stay house-ridden, rather than further her own goals. This prevented her from getting a job. However, I took her to the Army Community Service Building, whom was advertising classes for both GED and English as a single language classes. This simple assistance served other females within that domestic violence support group conducted by Family Advocacy Program well and empowered them to make better decisions towards their situations. The key takeaway is that I had to be the one to do it. Given the aforementioned details account of my experiences, I believe intimate partner violence in the military needs to be approached strategically. This strategic approach should involve accountability, care, and streamline. Furthermore, it should be approached with an understanding of all the dynamic factors involved. Accountability entails ensuring all military installations have memorandum of understanding on file with their local civilian law enforcement and support agencies. It appears from just my experience alone, equal efforts need to be given to address intimate partner violence that occurs off military installations. To my knowledge, not all branches of service and military installations have this memorandum of understanding in place. At the very least, it could include identifying if the parties involved in a domestic dispute are military. There should be an automated system that the local authorities can reference to validate whom are military personnel. Immediately following, procedures should be in place of how to contact the local military installation Provost Marshal Office. In return, this will ensure it appears on a blotter report for the military as a whole, as well as both military, police, and chain of command to have oversight. I am well aware that when it comes to jurisdiction in certain cases, the type of offense, severity, and monetary factors influence whom takes jurisdiction. Needless to say, oversight needs to be achieved. In 1929, the Uniform Crime Report System was developed, which is a nationwide program that law enforcement agencies report data on crimes that occur within their jurisdiction. This includes crimes reported. Perhaps it should become a policy that all provost marshals of the military installation be allowed to review that database, because if you don't have that oversight, and just from my experience alone, working with the Killeen Police Department and working with the local community, they elected not, they deserve, well, their decision was not to properly investigate, nor do I think that they thought that I deserve any form of justice. If that had if I didn't go through Third Corps or beg and plead for the military to take jurisdiction of my case, how would they have known? So I think that's why I'm proposing that a better memorandum of understanding be placed on, for all military installations, regardless of the branch of service, and that the provost marshal of the military installations be allowed to review these databases. What I have noticed is that each branch of service has their own central registry for reporting incidences and crimes involving domestic violence. They also have their own system that is unique to their branch to adhere to what is mandated by all DoD regulations. In return, they are each responsible for providing the data for the Defense Incident-Based Reporting System and what is required to the National Incident-Based Reporting System. You cannot win a battle with the lack of accountability, a lack of true standardization, and lack of constantly streamlining the process. If the Department of Defense can collapse logistics information systems of all branches of the military into one, they can collapse these databases into one so better oversight and accountability can be adhered to. One might think how much training is truly needed, but it should always be revamped and residual. Training is the only way to ensure the quality of care received or influence justice rendered. What resonates with myself the most is the lack of confidence expressed from the attorney in the panel, the military panel, that hears certain cases in military court. Perhaps all panelists should be subject to training on intimate partner violence and dispelling the myths associated with it. This training should be compelling, involve storytelling, solicits feedback, and encourage engaging dialogue. Panelists that receive this training should be identified by an additional skill identifier within the training requirements and resource system. Although dispelling myths, combating organizational behaviors and culture can prove to be an arduous task, it is not impossible, nor should it hinder constant efforts to try. At the very least, consider this recommendation so justice can be achieved. Clearly, you cannot always rely on local law enforcement agencies to do that particular job. Lastly, at the heart of the matter is the care. I'm asking that Special Victims Counsel be assigned to all victims of intimate partner violence in the military. We've heard of my process and how the unit's attorney made it clear she was not my direct attorney. This Special Victim Counsel can assist with the legal aspects, especially with both the civilian and military protective order that should be required. No one should be provided a packet and say, that's it, here, go do this, go do that. We have to constantly take into account one's emotional state, the duration and level of abuse when first saying, here is a packet. We are living in an informational age, but given how isolated the abused partner is, they may not have direct access to what is needed. In addition, it should be required that all spouses of military personnel have their own in-processing system on a military installation. I can only speak from an Army perspective, but perhaps it should be held at the Soldier Family Assistance Center. This will eliminate some of the spouses I've referenced whom didn't know where anything was, couldn't tell me what unit their spouse was in. All they could tell me was their spouse had the same patch I was wearing at the time. How then can we expect them to know the full extent of what assistance the family advocacy, first responders, and even their spouses' units can offer? To eliminate this problem, a separate in-processing should be performed for all spouses that includes family advocacy. Also, another factor that can be considered is organizing the domestic violence groups better, so targeted outreach can be performed. We are living in changing times with the relationship dynamics, preferred gender identification, etc. Furthermore, I'm well aware that civilian spouses are offered financial assistance throughout the process and even after conviction of domestic violence from the military. However, financial assistance was denied to my friend who was active duty and spouse was civilian. That's all. Thank you.
Thank you, Ms. McKinley. And Ms. Vega, so that we can have adequate time for the second panel, if you could keep your...
Sorry.
Oh, no, actually, there's no way. You put a lot of work into your opening statements. They're obviously going to be in the record. And Ms. Perry, in your particular case, there's a number of actions that were taken in our office about the specifics of your case. But thank you for your testimony. It was very helpful, particularly the suggestions for moving forward. Ms. Vega.
Good afternoon, Senators. I want to thank each of you for the opportunity of being here and sharing the experience and the stories of the survivors. My name is Iris Vega. I serve as the court advocate for Doorways for Women and Families, a nonprofit whose mission is to create pathways out of homelessness, domestic violence, and sexual assault. So my role as the court advocate was to work with survivors who would come into the courthouse. We work on protective orders, safety planning, and child support and custody issues. So these are the stories that I will share with you today in regards to what they experienced. Survivor number one came to the courthouse with her victim advocate from the military. And what she explained in her statement was that her husband had strangled her several occasions in front of their 9-year-old baby girl that was with them. She felt that she was scared, she didn't know what to do. She reached out to the military, Family Victim Advocacy, who in return referred her to get a protective order at the civilian court. She also had reached out to the commander, who was the military spouse commander, and he had placed the abusive partner out of the home and in the barrack. So she pretty much felt very supported through the military process. But her challenge was to face the civilian side, which was where we were. The civilian side, as you know, is not connected with the military. There's a big gap in communication there. So when the survivor comes in and her abusive partner is in the military, there's no way we can know what's happening in the military side. We don't know what the commanders have done. We don't know what the victim service has done with them. They just come with what they tell us. And our judges, most of the time, require proof. Did you call the police? Who's involved? Have you told somebody? A lot of the survivors that will come in do not have that because there's no communication between those two. The commanders are not there to explain what had happened. Sometimes the victim advocacy would not be there with them. They will be by themselves. In this case, she really had to retell her story again and again to different people, to the judge that was there to try to get that protective order in place. With a lot of work, she was able to do it. We were able to connect her with legal aid so they can represent her with a protective order. But the fact that she has to go through so many loops to be able to tell her story and give safety nets was something that we have to keep providing her with emotional support, to continue to that process. She was able to get one, secure one, and able to make out safety in that case. Our survivor number two came through us to the hotline. She described her husband as having post-traumatic stress disorder and that he had become increasingly angry towards her, violently. He would hit the walls, destroy personal property, and tell her that if she ever was planning on leaving him, that they both would end up dead. So she became very worried for her life and safety concerns. Because there was no physical abuse, it was very difficult for her to reach out. She finally decided to reach out to the not to the commander, but the higher ranking from her husband. And he told her that things will be taken care of. With time, nothing really happened. She then reached out to the Family Advocacy Center at the military, who gave her resources and told her where to call and where to go, but she was expecting more action from them. Nothing really happened. She decided to take things on her own hand, came to Arlington, got the protective order, the preliminary one, but it was very difficult again to make it permanent because there's no report, there's no police calls, there's no physical abuse. She strongly believed that the problem was that her husband was a sergeant and that nobody was willing to do anything because of that. She felt that she was left alone, that there was nobody there to support her in regards to the military side. But not only that, she also was challenged in our civil side because the judge, when we were in front of the judge, he looked at her and said, do you know you can ruin his career doing this? So it was not about the safety of the survivor. It was more about, his rank is a sergeant, you're going to ruin his career. This is the message that she got through from one place to everywhere that she went, that nobody was going to do anything because of that. She was denied a protective order. It never became permanent. We had to do a lot of safety planning. She eventually made it out, but it was a long way for her. It wasn't easy. We have to get her into counseling, get her outside resources that will be able to help her. And this also is the same thing you see over and over again when there's emotional and psychological abuse and you don't have a lot of the physical. It's very hard for the survivors to even reach out to the commanders, to the advocacy center when there's nothing that they can show for. Survivor number 3 came to us at the courthouse. She was sent actually by her commander because she was told that it would be easier and faster if she would do the protective order through the civil side first. She believed strongly that the commander did not want to do anything because, in her words, there were bodies with her husband. And she felt that he didn't want to get involved. It was a domestic violence situation, and it was between them. So he told her, if you get a civil protective order, then I can do something in here. And for her, she did have a lot of physical abuse. There was a lot of pushing to the point that he would grab her by the neck, choke her. And when she came up to the courthouse, she had bruises in her lips and her mouth, and it was very obvious. So in her case, it was not difficult to get a protective order because you could see it. But in the other cases, it wasn't that easy. So once she was able to get that protective order, she took it back to the commander, and he was able to proceed with that. So that's some of the challenges that not only in these cases we see, but in other cases that we had dealt with. One, which is a big one, is the lack of communication between the civilian side and the military. That includes CPS, includes nonprofits, even with the Victim Advocacy Center and other advocates that are outside, police, judges. There's no connection. And a way to break that has to be in place. Another big challenge is that we see, and we have seen it over and over again, is the officer's ranking. Many of the survivors are scared. They said, if I go forward with this, he's big, he's doing this, his career will be ruined, and I don't want to put that in him. And when they do decide to go forward, there's very little support in the military for that, and very little protection for them. So we, based on those challenges that we have seen, we think some of the recommendations would be to be able to put a system in place that will be able to facilitate the military and the civilian communication in all those different levels. The second would be to provide training. We believe so strongly that training does make a difference, and training the people who are in charge, higher ranks, officers, commanders, who are the ones who are making those decisions right now. And having the moment that victim, the survivor, is calling out and reaching out to the military, everybody who's involved, the prosecutors, the panels, everybody who's involved in that process needs to be trained. And they need to be trained in trauma-informed. And it has to be survivor-centered. And once again, collaborating. I think collaboration with the outside resources is very important. As we heard in some of the cases that we have here today, is outside resources, civilian resources sometimes make a big difference. So being able to have the military connect the survivors with those resources outside, knowing what they are, what they do, and connecting them is very important. And I believe that's the only way we can continue to nurture the culture that starts by believing that, yes, that happened. Start by believing the survivor and having a survivor-centered approach to them. Thank you.
Thank you, Ms. Vega. Ms. Perry and Ms. McKinley, thank you so much for the work you put into your opening statements, and we will have those for the record. And Ms. Perry, Ms. McKinley, this is the first, once we receive your testimony, the first exposure I've had to your case, but I'm sure that our staff, the committee staff and our office's staff will have follow-up questions for you. And Ms. Perry, you touched in your opening statement about Wilson's, it's impossible for me to call him Mr., had clearly behaviors that were exhibited in Australia and what I consider to be an unacceptable disconnect between the commands in Australia and back at Camp Lejeune that we're taking a personal interest in, and we're going to continue to speak with you and try to identify how we can prevent that in the future, but we also have to hold people accountable for this particular breakdown. So thank you all for being here today and for your time up here, and know that this committee is being held because we know that you're only two of so many victims that we need to do a better job as we move forward with policies on this committee. So thank you very much for your testimony.
Thank you so much.
Thank you. We're now going to transition to the second panel. The panel will consist of Ms. Stephanie Barnum, the Senior Policy Advisor for the Undersecretary of Defense and Personnel Readiness, Dr. Kenneth Dodge, Pritzker Professor of Early Learning Policy Studies and Professor of Psychology and Neuroscience at Duke University, Casey Taft, Ph.D., Professor of Psychiatry and at the Boston University School of Medicine, and Jacqueline Campbell, Ph.D., Professor of Nursing at Johns Hopkins School of Nursing. Thank you all for being here, and if we could have your testimony limited to about 5 minutes so that we can have adequate time for questions. And I'm going to take home state prerogative and start with Dr. Dodge.
Thank you very much for the opportunity to be here today. I'm a clinical psychologist, research scientist, and faculty member at Duke University in North Carolina, which is proud home to several military bases. Since Dr. Henry Kemp first identified the battered child syndrome in 1962, most of our nation's efforts have been directed toward protecting battered children after the fact of child abuse. This is understandable, but this is a never-win situation because the battered children keep on coming. So what I want to talk with you about is moving upstream. We've moved upstream to try to understand how child abuse occurs in the first place and how we can prevent it from happening beginning in the very first year of life. We've made progress in helping entire communities lower their infant abuse rate. I began my work in Durham, North Carolina in 2001. Since that date, the population-wide rate of child maltreatment in Durham, by official statistics, has declined by 67%. We've learned a great deal from scientific research on the causes of child abuse and neglect and early in life. We've learned that one size does not fit all. Some families become abusive because of alcohol or opioid or other drug use problems. Still other families, it may be maternal depression or domestic violence or family financial instability, or maybe for a young person, a lack of knowledge about child development and parenting skills. We know financial stress causes challenges that make the problem worse. For some parents, it's the stress of a crying baby at 2 o'clock in the morning, middle of the night. On the positive side, we know what can protect families, social connectedness to families, friends, pastors, and professionals can make a difference. So these diverse needs tell us that one professional intervention won't solve the problem for everybody, but we have interventions that can address the needs of different families. And so what we really face is an engineering problem. How do we understand individual family needs and then direct community resources to the right families at the right time, not to direct resources to all families when they don't need it, and not to let families fall through the cracks. So we've created the Family Connects approach to community child abuse prevention. This program's trauma-informed. It draws on the work from the National Center for Child Traumatic Stress and the Family Assistance Program and other good programs. Family Connects has 3 pillars. First, we try to reach every family in the community at the time of birth. We go to the hospital where the birth occurs. We invite ourselves into the home. A trained nurse will have 1 to 3 home visits, up to 7 contacts with a family. She tries to understand what that particular family needs. Maybe it's professional substance abuse treatment. Maybe it's a parenting support group. Maybe it's an emergency housing loan. She then tries to connect the family. She does education, universal education on sleeping and crying and breastfeeding, a number of other areas. And then she also connects the family to the community resources that that particular family needs. The second pillar is if we are going to make these community resource connections, we have to align all the community resources. In Durham, where I live, we have an electronic annotated directory of over 400 community agencies that we have rallied and learned about to help families at the time of birth. The nurse has this directory at her disposal as she works with families. The third pillar is an integrated computer data system that tracks every family's contacts and progress so that we can be efficient in our work, we can hold our staff accountable, we can hold agencies accountable, we can not direct too many resources toward one family but spread them out appropriately. We can track progress and evaluate the impact of what we do. Now, the Family Connects program is brief, it's temporary, it's community-wide. It costs about $500 per family for every family in a community. All right. Many families use less than that. Some families use more, but that's the average. Now, we've evaluated the Family Connects impact as rigorously as we can. We've had 2 randomized controlled trials, a 3rd field quasi-experiment, a lot of qualitative evaluation as well, with over 7,000 families in these experiments and trials so far. Our published evaluations show that the Family Connects program decreases mothers' anxiety, increases their confidence, improves parenting, but most importantly, it reduces official rates of child abuse in a community by 1/3. Also reduces injuries and illnesses in emergency rooms as detected by official records. So we're now disseminating the Family Connects program across the nation. We're working with 28 communities today. We plan to grow to several hundred communities. With each new community, we learn and we adapt the program. We believe military communities, such as the Army's Fort Bragg near Fayetteville and Marines Camp Lejeune in Jacksonville, are terrific opportunities to promote infant healthy development and prevent child abuse. We believe we can lower the child abuse rate in these military communities. Thank you.
Thank you, Dr. Dodge. Dr. Campbell.
I want to thank the committee for having us. I especially want to thank both of you senators for your eloquent, informative opening remarks. I'm a nurse researcher at Johns Hopkins University School of Nursing. I've done research on domestic violence and health outcomes for more than 20 years. I was a proud member of the congressionally appointed U.S. Department of Defense Task Force on domestic violence in the military from 2000 to 2003. In that role, I was able to travel all over the world and observe and listen to domestic violence survivors, domestic violence offenders, and those that were trying to deal with domestic violence in the military. I learned so much about the military and grew to an even greater level of respect and honor for all of our armed services at every rank. Most of the recommendations that we made as part of that domestic violence task force were adopted by the military. And we could hear from some of the testimony, some of the things that are supposed to be put into place. The problem is now, of course, implementation, sustainability, continuous evaluation, and continuous improvement. That's where I think we have fallen down. One of the recommendations we made was to conduct a systematic, population-based, regularly repeated, and importantly, totally anonymous survey of active duty military women and active duty military wives of active duty military women. This was done by CDC in 2010. It is being repeated now in 2016, 2017. And those results have not yet been made public. Fortunately, there is good data from that survey about what was happening to active duty military women. What is unfortunate is part of that survey was questions about injury. That injury data has never been published. The military has taken over on that data and has not allowed CDC to publish it. So we do not know how much injury there was to active duty military women. We also know that although it's being repeated now, there is not funding from the military to repeat it after 2016 and 2017. That absolutely has to be done. Yeah. From that data, we learned that the domestic violence against active duty military women was very similar to the amount of domestic violence against civilian women. About 40% of civilian women experience lifetime physical violence, rape, or stalking by an intimate partner, and about 31% of active duty military women and 30% of the wives of active duty military men. So very similar percentages, and approximately a third of women in the military experiencing domestic violence. For active duty military women, that translates to 56,000 active duty military women who have been abused by a partner or ex-partner sometime in their lifetime. 40,000 severely physically abused women by a partner. And even if we look at the past 3 years, which the rates are lower, and that's similar to civilian women, 21,000 abused in the past 3 years, 9,000 severely abused active duty military women in the past year, and 6,000 of the even more severe repeated physical violence or sexual assault. And that's every year. We must use that data intelligently to develop policy and to do further research on what is reported and what is not reported to the military. We know that actually officially reported domestic violence is far lower than the actual domestic violence, just like we know that about sexual assault. What is missing from the NSVIS, as it's called in CDC, as I mentioned, is the health outcomes of domestic violence for active duty military women. And we have new science, as Senator Gillibrand mentioned, about traumatic brain injury that happens to abused women in the civilian world. We need to apply this new knowledge to domestic violence victims in the military, as well as to our soldiers that are injured by blast injuries and our athletes. This is one of the long-term health outcomes of domestic violence that we are beginning to discover. We have known for a long time that women who are abused by their partners have long-term neurological problems. What we didn't know is why. What we know now from new data, my team published it in 2017. We have some data from Eve Valera at Harvard showing definitively that women who are beaten in the head or have facial injuries, hit in the eye, hit in the ear, fractured jaws. I always make the analogy, we know what happens to boxers over time. And domestic violence victims are repeatedly hit in the face, repeatedly hit in the head. And they're also strangled, as was mentioned. Ms. Vega talked about the woman who was strangled by her partner in front of their 9-year-old daughter. And what was recommended to her was a protective order. Important, yes, But what about medical care for that strangulation? We know that strangulation leads to long-term brain injuries. And what about counseling for that 9-year-old? That also is incredibly important so that we can prevent these children that are so often exposed to domestic violence, both in the military and outside, from having that cumulative trauma that we know is so important in terms of increasing the risk of them using violence in their adolescent and adult relationships. We know now that we have to heal from that trauma as well as teach kids to do better. That it's not just cognitive reasoning that makes the difference in whether or not people use violence. It's also, if they've had cumulative trauma, what that does to the brain. We know much more about that. We also have really good science now in terms of how to treat people with traumatic brain injury in the military. We do a great job of treating with the most advanced neurological techniques our blast injury victims in the military who have TBI. We do not do the same for our active duty military women who have TBI from domestic violence. So we need to routinely screen in all of our active duty military health facilities for experiencing domestic violence. We need to do it in a way, and as was talked about in terms of restricted referrals versus non-restricted reports to military command, all of that is useful. But we need to be sure to be screening not for just present domestic violence, but for past domestic violence. These neurological problems last long after someone has left an abusive relationship. We heard from an incredibly brave, smart, resourceful victim of domestic violence. And I always wonder how well they have been treated for those long-term medical problems. And we heard about hers in terms of requiring surgery, et cetera. As soon as we find a victim of domestic violence in an active duty military setting, we need to make sure that we're using a traumatic brain injury screen. There's a modified screen that Kathleen Iverson, who's in the VA, has used with veteran women that can be where women can disclose whether or not they've had a strangulation event and whether or not they've had these kinds of head injuries that would lead to traumatic brain injury. And again, it's those repeated blows to the head and/or strangulation. That's the issue. We can use those to screen for TBI amongst women, and we can use those to decide how to best provide treatment for those women for the traumatic brain injury. My last note is, first of all, in terms of the other kind of injury that we too often incur for both civilian and military women, and that is gunshot injuries. And what we know now in terms of what the person we know of as the Texas shooter was so egregiously violent toward his wife in the military that he was sentenced to a year in the brig. That is really serious domestic violence for that to happen. And yet, the record of that domestic violence did not get into the background check database. And he legally obtained a firearm. And what we talk about, the bill we talk about, fix NICS, is not going to fix that problem. We have to look at that very carefully in terms of how that would be allowed to happen to make sure it never happens again. And as I mentioned, in terms of prevention, those kids that are witnessing domestic violence, in terms of treatment for their trauma so that they don't go on to be using domestic violence as they grow older. Thank you.
Thank you, Dr. Campbell. Dr. Taft.
Good afternoon, Chairman Tillis, Ranking Member Gillibrand, and members of the subcommittee. Thank you for the opportunity to discuss my observations on domestic violence in the military. I'm appearing today on behalf of Boston University School of Medicine and not on behalf of the Department of Veterans Affairs. The focus of my work is on understanding how domestic violence develops in service members and veterans and in developing evidence-based programs to prevent or end that violence. My programs focus on those engaging in domestic violence or those who are at risk for violence. Trauma and PTSD are among the strongest risk factors for domestic violence. When a service member has PTSD, their domestic violence risk increases threefold. When a service member does not have PTSD, their violence rates are virtually the same as in civilians. In other words, existing data suggests that it's the trauma and PTSD that most strongly drives the risk for domestic violence, not pre-existing violent tendencies in those who join the military. However, it's also critical to understand that PTSD does not cause domestic violence. It only increases risk. Although PTSD is related to higher violence risk, most of those with PTSD aren't domestically violent. In other words, we must not think of violence as a symptom of PTSD or something that's inevitable. Those who engage in domestic violence ultimately make a choice to be violent and are responsible for their own behavior. To better understand how trauma increases violence risk, it's helpful to consider how trauma can alter how we respond in social situations. When in a war zone or dangerous area, the service member may be extremely alert to threat and learns to see threats that others don't see. This is obviously adaptive in a war zone, but when the service member returns home, they may be more likely to develop a mindset where they assume that others have hostile intentions towards them. They may begin to falsely assume that their partner is trying to push their buttons, is cheating on them, or trying to do them harm in some way. When one assumes the worst in their partners, they'll be more likely to engage in controlling and abusive behavior. Service members exposed to trauma report that their experiences have changed the ways that they view the world. For example, virtually every violent service member I've worked with describes difficulty trusting others. This difficulty trusting may be due to observing people harming others in the war zone, or perhaps they felt betrayed or didn't know whom they could trust during their traumatic experiences. These feelings of mistrust can often carry over into intimate relationships and are often a precursor to coercive and controlling behavior. Power and control themes are also important with service members exposed to trauma. Perhaps they felt powerless while exposed to trauma and they attempt to exert power and control in their home environment that they didn't have during their trauma. They may also use more dominating forms of communication that are effective in a military context, but not in the home context. We need to take a trauma-informed approach when working with those who engage in domestic violence, meaning that we discuss the role of trauma throughout the entire intervention process. Trauma-informed care is standard in every other area of intervention, but the domestic violence field has been slow to adopt it, even with military populations for which trauma takes on particular importance. Some worry that by taking a trauma-informed approach, we're excusing abusive behavior. In fact, when we listen to the stories that service members tell about their trauma, it lowers their defenses and they open up and take greater responsibility for their abuse. If we listen to their stories, they'll join with us and work to end their abusive behavior. We can and should talk about the role of trauma in abusive behavior while emphasizing accountability and personal responsibility at the same time. This is not just my theoretical speculation. Through funding from DoD, CDC, VA, and the Bob Woodruff Foundation, my team has developed and implemented the Strength at Home programs, trauma-informed group therapy programs to prevent and end domestic violence. These are the only programs demonstrated effective for veterans and service members through randomized controlled trials. So we now have good evidence that a trauma-informed approach is the best way forward to prevent and end domestic violence in service members at risk. I believe that the military response to domestic violence is far ahead of the civilian response. Through their family advocacy programs, DoD uses a coordinated community response to deal with the problem and has a system for identifying abusive behavior and getting folks the help that they need. DoD's standards for best practices to deal with domestic violence are also well thought out and trauma-informed, and that's what Jackie was just referring to. She was an important part of that process. One recommendation that I have is that DoD adopt a system where they identify only trauma-informed programs truly shown to be effective to prevent and end military domestic violence through clinical trials, and work to consistently implement these programs across DoD. Currently, there are some programs on installations that don't meet this standard. This approach would ultimately benefit military families who experience domestic violence. Mr. Chairman, thank you again for the opportunity to testify, and I'd be pleased to answer any questions.
Thank you, Mr. Taft. And Ms. Barna, I want to thank you and Secretary Wilkie for having you here.
Ranking Member Gillibrand and members of the subcommittee, the Department of Defense is committed to preventing and responding to domestic abuse, intimate partner violence, and child abuse and neglect in the military community. On behalf of Mr. Wilkie, the Undersecretary of Defense for Personnel and Readiness, and the cadre of dedicated and expert professionals who comprise the DoD Family Advocacy Team, I appreciate the opportunity to appear before you today to discuss the Department's coordinated community response to preventing, identifying, and responding to domestic abuse, child abuse, and neglect. The testimony of Mrs. Perry and Ms. McKinley and Ms. Vega was both heart-wrenching and deeply concerning from our perspective. I want each of you to know how much I respect the courage that you have demonstrated over time and here today in testifying, in pursuing care and justice for those that you love, for yourself, and in the case of Ms. Vega, for those she has committed to protect and assist. I deeply appreciated the opportunity to hear what you have to say, and I can assure you that the department will work with this committee to be responsive to the issues that you have raised in your testimony. To the members of this committee, I look forward to taking your questions and to the discussion.
Thank you very much, Ms. Barna. Dr. Dodge, thank you for the time. Well, thank you for coming up here first and foremost in your work. And I think that your review of the Durham experience since 2008 was extraordinary. I mean, a reduction of over 60% and going from a community that was above the state average, that was itself above the national average, and doing the work that you've done proves that it works. You've also, I immediately went to how you pay for it and also how you measure the benefits, and I think you have a very good story to tell there. So with the committee, I mean, if you could briefly talk about some of the ways that you believe there's a compelling economic positive impact, I'd like to talk about that, and then we'll also make sure that our staff follow up, because I think what you're doing there could serve as a basis for something that we should identify a way to pilot, work with the department, and identify a way to have a public-private partnership, as you've done in so many other places now across the country. But if you could briefly talk a bit about the savings that we have the most important thing, which is the benefit to the family, but the savings and the other positive impacts that I think build a compelling fiscal case.
Thank you, Senator Tillis. Yes, if we look merely at the two primary outcomes of reducing emergency room visits in the first 2 years of life for illnesses and injuries, and reducing official child protective services investigations for child abuse, we find in Durham that we save at least $3 for every dollar that we spend in the program in the first 2 years of life. We continue to do these economic studies as children get older, and we're doing them in our other communities as well. So I think there's a good economic case to make. Part of the problem is we, of course, cannot, in the meantime, stop serving those already battered children and abused children. So there is an investment that needs to be made. I think that's the nature of it. Second, as far as how do we pay for it, we're in 28 communities across the nation, and each community pays for it in different ways. In Durham, the county commissioners have elected to use tax dollars to pay for one little part of it. Philanthropy pays for another part of it. We capture some modest Medicaid funding for part of it. And we capture some state grants as well. In other communities, we have found that private, for-profit healthcare agencies will pay for it or have paid for it in several communities, perhaps because they think it's a good thing for their clients, their patients, perhaps because it's good public relations, but also perhaps because they realize it will save them dollars down the road in the long run. So I think it's a combination of public funds, private funds, and nonprofit philanthropy. In military communities, I think it can be a combination of the military plus the surrounding communities. So I know fairly well Fayetteville, Cumberland County in our state of North Carolina, where we're beginning to interact with Cumberland County. And that community could provide some resources, but also the Army's Fort Bragg could provide some resources for those families. So I think there are creative possibilities here.
Thank you very much. Ms. Barna, I think this may be the first, probably is the first time you've heard of this particular program, but I would like an opportunity for us to maybe talk about it and see if there's some way to explore an application on a pilot basis or possibly other programs that we can at least possibly make some headway for the support of military families.
Absolutely, sir. We'd be happy to do it. We're familiar with Dr. Dodge's work. We're great admirers of it. And we would be very interested in the outcomes of the current pilots.
Thank you very much. Senator Gillibrand.
Thank you so much, Mr. Chairman. Dr. Taft, can you elaborate on the types of barriers researchers and clinicians face when trying to start these types of programs?
Barriers in starting the program on an installation? Correct.
Prevention programs for military families.
Right. So we actually have a DoD-funded clinical trial / implementation study right now at Madigan Lewis McCord, where we are trying to implement our couples-based prevention program. And this is a program that is focused on preventing violence in couples at risk. So before there's any violence going on at all, and we've shown through a CDC trial that that it's effective, that we compared it in clinical trial to support groups, and it was more effective than that. So we're now attempting to implement this on an installation currently. And, you know, I mean, to be honest, up to this point, we've been trying to get through the IRB, the military IRB, for like two years. So that's been our primary barrier thus far. But I think the most important thing is getting buy-in, and our experience has been reaching out to the partners, to the family members is probably the most successful approach, rather than reaching out directly to the service members who don't necessarily want to go to couples therapy or any kind of conflict prevention kind of program. So I think that's the biggest barrier, the biggest challenge is reaching directly to the partners, finding ways to reach them. When we did our clinical trial, we reached them through Strong Bonds retreats, through Yellow Ribbon events, any place where we thought we could talk to partners directly, that's where we would go.
Dr. Dodge, I understand that our youngest children are the greatest risk of fatality from abuse and neglect, and I remember how difficult it was as a new mother, and I can't imagine what it would be like to go through that kind of experience without a strong support system. So what are the barriers that families seeking help encounter when it comes to caring for their children? And are there policies and procedures that would reduce these barriers to seek help and the stigma of child abuse and neglect that would make prevention programs more accessible?
Yes, thank you for that question. There are barriers that we've learned about from interacting with families over time. One barrier is the stigma of reaching out for help with mental health problems, with financial problems, even with child care problems. Another barrier is the belief that one should do it alone. One of the things we say to mothers in the hospital room after giving birth is we congratulate the mother and we welcome the baby in the community. We say every parent can be successful, but no parent has ever been successful alone. We're successful by surrounding ourselves with others. So we try to set up that norm in the family's eyes so that they don't feel that they have to do it alone. There are ways to overcome those barriers. Our approach is universal. Every family is offered the opportunity, so there is no stigma. So there is no belief that you have to do it alone or should even do it alone, right? But it's universal. But of course, we don't want to spend thousands of dollars on every family, so we have to have a way to triage and to get the right resources to the right families at a particular time. So there are barriers, but I think we can overcome them with a universal public health kind of approach.
Thank you. Ms. Barna, currently we do not have numbers reflecting the estimated prevalence of child abuse and intimate partner violence in the military, only the reported cases. Why doesn't the Department of Defense survey military members and their dependents to try to establish an estimated rate of prevalence so that we have a better idea of the scope of the problem?
Senator Gillibrand, we have heard you, and we are in the process of actually incorporating questions about domestic violence in our military spouse survey. There are questions about domestic violence and abuse that will be inserted into our workplace gender relations survey. It is always, of course, a challenge for us to endeavor to survey children in an effort to ascertain prevalence. Our concern is that such a survey would be quite skewed simply because our practice is that for children under the age of 18, we would certainly require parental consent and that we likely would not receive such consent from households where abuse is ongoing. And as well, just the challenge of interviewing and soliciting the children's response makes that kind of prevalence survey very challenging. But we are hopeful that the military spouse survey and again, the gender workplace relations survey will assist.
Yeah, you could get some of it from the spousal survey, I suspect. The Family Advocacy Program publishes a report each year containing the number of reported allegations of child abuse and neglect and intimate partner violence and the number of cases that met the criteria of the program's guidance. However, in the annual report, there's no data on the outcome of such cases in terms of prosecution by civilian or military authorities, recidivism rates, or treatment outcomes. Can you give us guidance on why Family Advocacy does not track and report this data?
Actually, I could speak from a couple of perspectives there. The Family Advocacy Program is focused persistently, first, foremost, always on the victim. Our primary concern is the victim. We have concern for the offender, and certainly we will offer treatment to an offender where treatment is suggested and the offender will participate. But it's all with a view to helping the victim. And so we don't really get involved other than as part of the coordinated community response in the law enforcement, the legal, and the command response to holding the offender accountable. We do have great concern that if victims were to regularly perceive that our objective is offender accountability, victims would not come to us, that they would be hesitant to, as you heard today, ruin the careers of people that they care about, people with whom they may share a child. We also have concerns that commanders who today would preventatively refer a service member to us saying this individual needs service wouldn't do it. And finally, there are practical concerns. If you saw in my statement our discussion of fatality reviews, we complete fatality reviews only after the accountability process is done, meaning that we are 3 years behind in fatality reviews. So you are seeing our fatality reviews of cases where the accountability actions have only been completed and it's 3 years later in time. We don't want to wait 3 years to provide you with data about how our victims, and in some cases, how our offenders are responding to treatment.
Thank you. Thank you, Mr. Chairman.
Well, thank you all, and Dr. Campbell, I think your point on getting sufficient data is critically important for it to instruct us in terms of additional actions we need to do here. This hearing is not a once and done moment. It's a process. I think Senator Gillibrand and I are very focused on this issue, as evidenced by the fact that we held this hearing, but what's even more important is the dialogue that follows. So Ms. Barnett will be following up with the department and to each one of you. We'll keep the record open through Tuesday of next week. We may submit questions to you for the record. If you're able to respond, we would appreciate it. But more importantly, as you track what we're doing here, please make sure you contact my office and the ranking member's office for any suggestions and improvements that we can make. Thank you all. And again, Ms. Perry, Ms. McKinley, thank you for your courage. We're going to do everything we can to make sure that your stories are becoming fewer and fewer until we can get them to be none. Thank you so much, and thank you for traveling here.
Thank you.
Hearing's adjourned.